I call this meeting to order. So welcome to meeting number 114 of the House of Commons Standing Committee on Public Safety and National Security. Before we begin, I would like to ask all members and other in-person participants to consult the cards on the table for guidelines to prevent audio feedback incidents. Please take note of the following preventative measures in place to protect the health and safety of all participants, particularly the interpreters. Only use a black approved earpiece. The former gray earpieces must no longer be used. Keep your earpiece away from the microphone at all times. When you're not using your earpiece, place it face down on the sticker placed on the table for this purpose. Thank you all for your cooperation. Today's meeting is taking place in a hybrid format. I would like to make a few comments for the benefit of members and witnesses. Please wait until I recognize you by name before speaking. A reminder that all comments should be addressed through the chair. So pursuant to the order of reference referred to the committee on Wednesday, May 29th, 2024, and the motion adopted by the committee on Monday, May 27th, 2024, the committee resumes its study of Bill C-70, an act respecting countering foreign interference. I would like to provide members of the committee with a few comments on how the committee will proceed with the clause-by-clause consideration of Bill C-70. So it's going to take a couple minutes, so grab a coffee. As the name indicates, this is an examination of all the clauses in the order in which they appear in the bill. I will call each clause successively, and each clause is subject to debate and a vote. If there are amendments to the clause in question, I will recognize the member proposing it who may explain it. I would like to remind committee members that pursuant to the order adopted by the House on Thursday, May 30th, all amendments had to be submitted to the clerk of the committee by 4 p.m. on Friday, June 7th. As a result, the chair will only allow amendments submitted before that deadline to be moved and debated. In other words, only amendments contained in the distributed package of amendments will be considered. When no further members wish to intervene, the amendment will be voted on. Amendments will be considered in the order in which they appear in the package of amendments. In addition to having to be properly drafted in a legal sense, amendments must also be procedurally admissible. The chair may be called upon to rule amendments inadmissible if they go against the principle of the bill or beyond the scope of the bill, both of which were adopted by the House when it agreed to the bill at second reading, or if they offend the financial prerogative of the Crown. Amendments have been given a number in the top right corner to indicate which party submitted them. There is no need for a seconder to move an amendment. Once moved, you will need unanimous consent to withdraw it. During debate on an amendment, members are permitted to move sub-amendments. Approval from the mover of the amendment is not required. Sub-amendments must be provided in writing. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended. When a sub-amendment is moved to an amendment, it is voted on first. Then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. Pursuant to the order adopted by the House, if the committee has not completed the clause-by-clause consideration of the bill by 6:30 p.m., the chair shall allot each party no more than 5 minutes for each of the remaining amendments and clauses, and the committee shall not adjourn the meeting until it has disposed of the bill. Finally, if members have any questions regarding the procedural admissibility of amendments, the legislative clerks to my right are here to assist the committee. However, they are not legal drafters and cannot respond to legal questions. So I thank the members for their attention and wish everyone a productive clause-by-clause consideration of Bill C-70, no matter how long it shall take. So I would like now to welcome the officials with us. With the Canadian Security Intelligence Service, we have Sarah Estabrooks, Director General, Policy and Foreign Relations. We have Maria R. Senior Analyst, Strategic Policy. With the Department of Justice, we have Jennifer Poirier, Senior Counsel, Mark Scrivens, Senior Counsel, Karine Bolduc, Counsel, and Kieran Dyer, Counsel. With the Department of Public Safety and Emergency Preparedness, we have Richard Bilodeau, Director General, Saskia Van Batem, Director, David McIntyre, Acting Director, and Fenton Ho, Acting Director General. who is in the public gallery, apparently. Clause by clause consideration. Okay, so pursuant to Standing Order 75-1, consideration of Clause 1, short title, is postponed. The chair calls Clause 2. So there are no amendments submitted to Clauses 2 through 33. Do we have unanimous consent to group them? Yes, we do. Shall Clauses 2 to 33 carry? Clauses carried. All right. That brings us to Clause 34. The amendment is block number 1. Monsieur Villemure, do you wish to move it?
Merci, Monsieur le Président. J'aimerais...
Thank you, Mr. Chairperson. I'd like to move the following amendment. It's more semantic than anything else, and the purpose is to ensure that the offence, that it be, in fact, amended so that it's, there's an equivalent with the English version that is more accurate.
Nous sommes d'accord avec l'amendement.
We agree with the amendment.
Okay. Shall BQ1 carry? Yes. Yes? Carried. That brings us to CPC1. I guess that would be in the name of Mr. Shipley, or?
That'd be in my name, and I'll.
Okay.
Pardon me, Mr. Chair. That would be in my name, and I will move that amendment, and I'll reserve any commentary to my colleague, Mr. Chong here.
Yeah, Mr. Chair, this doesn't change the substance of the intent of the clause, but simply clarifies that the person being briefed may be told of personal information as it relates to themselves, allowing them to be briefed, and that amendment comes out of testimony that the committee heard from CSIS officials.
Okay, thank you. Any further, Mr. Gahir, please.
Chair, I'd like to move a sub-amendment, if I can.
You have submitted a sub-amendment in writing? Do we have to do that, right?
Can you ask him?
Do you have it in writing? Can you submit it
Yeah,
in
yeah.
writing?
I think it's already been submitted.
Okay.
It's going to be submitted.
Okay. That's the requirement, right? Mr. Gahir, it's going to be a long night. If you would move the motion, we will then suspend, and the analysts can have a look at it. Okay?
Sure. I move the sub-amendment.
Can you say? Can you read them in?
I can, yeah, sure. No. So look, the proposed language, which I'll propose in a minute, would still include a general prohibition on the disclosure of personal information about Canadians and persons in Canada, but it would add an exception to ensure that CSIS could disclose an individual's personal information to that individual as part of a disclosure to build resiliency against threats. And in terms of the actual edit to the language itself, in 2.1b, after the comma, at the end, the last sentence, I would change it to other than personal information of the individual to whom the information is disclosed. And in C, I would change it to, after entity, after the end of that sentence, comma, other than the name of the corporation or entity to which the information is disclosed.
Mr. Chong?
Mr. Chair, could he repeat that, please?
Go ahead, please.
Sure. So in 2.1b, the final sentence after the comma would be changed to other than personal information of the individual to whom the information is disclosed. And in C, after the end of entity, the end of the sentence, I would put a comma, and I would put other than the name of the corporation
It's supposed to be modified.
or entity to which the information is disclosed, period.
Thank you, Mr. Gahir. We'll suspend for a few minutes while we get squared away here. Messes up the rest of the bill. What is written in the actual text of this is acceptable, right? So what is shown here on this summary is
Sub-amendment.
so the sub-amendment, which does not affect Part C here, is acceptable. I'm sorry? Go ahead.
Sure, but I think we would still want the edit for B, right?
Yes.
Which is just a small edit from "and" to "the." I think we're clear.
We're all clear?
Yep.
That makes all of you.
So,
but not
so,
me.
so just to clarify, Mr. Chair, you've ruled the sub-amendment as it relates to C out of order,
Yes.
but you've ruled the amendment, the sub-amendment as it relates to B as in order.
Yes. So I'm a little confused by this because on this, which is a summary of your amendment put into the text, your amendment doesn't have this part, this sub C in it, right? So the amendment itself is good. This depiction of the amendment is kind of off. So your sub-amendment, Mr. Gahir, to modify C is, that part, it doesn't work. But the modification to CPC 1 that is good is good, in my understanding.
On the sub-amendment first, and then?
Yes, we do.
Yeah, okay.
Is there any more comments on, any more confusion we can add to the sub-amendment? No? All in favor of the sub-amendment? Aye. Right. So any further comment on the CPC 1 as amended? None? All in favor? I take that as yes. So CPC 1 as amended, carries. That brings us to clause 34 with no amendments. Shall clause
As
34?
amended. Clause 34.
Oh, sorry, that was clause 34. So shall clause 34 as amended carry? Yes, okay. So there are no amendments submitted to clauses 35 through 41. Do we have unanimous consent to group them? Yes? Shall clauses 35 to 41 carry? Yes. Thank you. So that brings us to new clause 41.1. That is Government 1. Who wishes to move? Mr. Gahir, go ahead.
Sure. Chair, we'd like to move Government Amendment 1. This amendment will ensure that CSIS officers and those who aid CSIS have the same legal liability extended to them under the new warrant provisions that exist in the current CSIS Act. I can read the summary if you want, or we can just leave it to the officials to explain any other details. It's fine.
Is there any discussion on G1? Let us get through this G1. Is there any discussion on G1? Are we ready to vote on it? All in favor of G1? Carried. So that will so we have a vote on the floor.
I believe there's agreement between the parties to just take brief breaks in between the votes and have unanimous consent to carry through while we vote through these various votes.
So I understand there is a unanimous consent. Is that correct? Yes. Okay. So let's get democracy underway here. Oh, okay. Well, in that case, that brings us to clause 42 and NDP 1. Mr. McGregor, do you wish to move NDP 1?
Yes, Chair, I do wish to move NDP 1. So small change to clause 42, simply changing the word shall to may. And the rationale is that, CSIS is being given a significant new production order and warrant powers, and I think that there have been some concerns from civil liberties groups on this. So to address this, we propose changing it to allow a little bit more leeway.
Okay, any discussion? Shall NDP 1 carry? Yes? Carried. So this should be on this,
So
right?
shall clause 42 carry?
Yeah.
And then-
So shall clause 42 carry, which includes the G1 and NDP 1? Shall clause 42 carry? Yes? Carried.
Yep. As amended.
Okay, as amended, sorry.
We suspend,
Open now?
pause just for a minute to vote, Mr. Chair.
Absolutely. So we'll pause and everybody gets to vote. It's a fascinating process. Do we have unanimous consent to group them? Yes. So shall clauses 43 to 52 carry? Yes. Thank you. That brings us to clause 53 and NDP 2. Mr. McGregor, do you wish to move NDP 2?
Yes, Mr. Chair. So as members know, Clause 53 is a rather large clause with all of those significant amendments to the Security of Information Act. And I was just sort of recognizing that the sentencing is pretty strict in a lot of these, and I understand that absolutely for the crimes being committed, we do need to have those strict sentences. But I'm just sort of making some changes to make sure that instead of having the word, I believe, shall be served consecutively, is that they may be served consecutively. And so, again, there's still an option for a judge, based on the circumstances of the case, to impose consecutive sentences. But there's also an option to give a little bit more leeway, because, again, the circumstances of each case can vary considerably. So that's what my amendment is attempting to do throughout Clause 53.
Mr. McGregor, is any discussion? Mr. Gahir?
Yeah, thank you, Chair. So we see that this motion would give a sentencing judge the express discretion to apply a consecutive sentence, but they wouldn't be required to impose one. So we just wanted to ask the officials, perhaps, what the thought process was during the drafting of this language.
Thank you for that question. The provisions that require a mandatory consecutive sentence be imposed for the new Security of Information Act offenses mirror similar provisions in the terrorism offense regime in the criminal code and the organized crime regime in the criminal code, which similarly require the imposition of consecutive sentences for convictions of those offenses. So the intent in the Act is to reflect the seriousness of foreign interference offenses and to suggest that they are equally as serious as terrorism offenses and organized crime offenses. I will additionally point out that Section 718.2 sub C of the Criminal Code allows the sentencing judge discretion to ensure that the overall total sentence is not unduly harsh or unfair in the circumstances.
Thank you. Any further questions? Ready to vote on this amendment? All in favor of, shall NDP 2 carry? Can we ask for a recorded vote? Mr. Clerk, if you would.
Oh, okay.
Mr. Biddle? No. Ms. Zaid?
No.
Mr. Gay?
No.
Mr. McDonald? No. Mr. Longfield?
No.
Mr. Caputo?
No.
Mr. Chung?
No.
Mr. Matz?
No.
Mr. Shipley?
No.
Monsieur Villemur?
Oui.
Mr. McGregor?
Yes.
Yes. 2 yeas, no nays.
Thank you. The amendment is negatived. That brings us to the end of Clause 53. Shall Clause 53 carry? Yes. All in favor? Yes? Carried. There are no amendments submitted to Clauses 54 through 60. Do we have unanimous consent to group them? Yes. Shall Clauses 54 through 60 carry? Yes. That brings us to Clause 61 and CPC 2. Mr. Caputo, if you...
Thank you, Mr. Chair. At this time, I will be moving CPC 2. This is a very basic amendment as it relates to essential infrastructure, at what stage in its development or construction that it's in. Thank you.
Any discussion? No discussion? All in favor of CPC 2? Carried. That brings us to NDP 3. Mr. McGregor.
Sorry, Chair, I'm just getting to the page here. Yeah, okay, so this amendment is based on the testimony we received from Ms. Emmanuelle Rayo. And during her testimony, she was just saying that if we didn't specify that it was the Attorney General of Canada, then it would be the Attorney Generals of the provinces. And just given the seriousness of these criminal code changes, basically, sabotage, I thought it best that we specify that it's the Attorney General of Canada that is actually referred to. And so a pretty simple amendment, just changing reference to which Attorney General it is.
Mr. Gayer.
Great, thank you, Chair. So the prosecution of most criminal code offenses, as we know, including sabotage, is the responsibility of the provinces. But I'd like to ask the officials their thoughts on the drafted language.
Thank you. It is correct that most criminal code offenses, and the sabotage offense appears in the criminal code, are prosecuted by provincial prosecution services. Sabotage in its current form in the criminal code is prosecuted currently by provincial prosecution services. The effect of this amendment would limit the consent for the commencement of a prosecution to the Attorney General of Canada, but does not specify that the ensuing prosecution would be conducted by the prosecution service, Public Prosecution Service of Canada. So the effect would be that the consent would have to be provided by the Attorney General of Canada, and then the ensuing prosecution, if it in most cases related to matters within the provincial jurisdiction or that are normally prosecuted by provincial prosecutors, would then continue to be prosecuted by a provincial prosecution service. That's my reading of the effect of the provision. I will also add that in Section 2 of the Criminal Code, Attorney General is defined as both Provincial Attorney General and the Attorney General of Canada.
Okay, Mr. McGregor?
I just had a question for Mr. Scrivens. Sir, you had said most offenses are prosecuted by provincial attorney generals. Can you just clarify what the exceptions might be?
There is some exceptions. For example, the terrorism provisions of the criminal code can be prosecuted by the prosecution service, the federal prosecution service, and in general usually are prosecuted by the Public Prosecution Service of Canada.
So I think, Mr. Chair, based on that response and the seriousness of existing criminal code offenses that are looked after by the Attorney General of Canada, I think there is potentially an argument to be made, given these amendments to the criminal code and the seriousness of the offenses listed. You could find an argument that's saying it's in line. But again, it's up to colleagues to determine whether that is so.
Okay, is there any further discussion on this amendment? Shall NDP 3 carry? Yes, Miss.
Sorry, I
O'Connell.
want you to finish the vote call and then.
Oh, yeah, so shall clause 61 as amended carry? Yes, yes. Sorry, Miss O'Connell.
Sorry, apologies for being late. I had to finish question period in the House. I just wanted to quickly apologize and retract from my comments about Mr. Villemure at the last meeting, and I really look forward to working with him on this committee and on this important bill. Thank you, Chair.
Thank you, Ms. O'Connell. So there are no amendments submitted to clauses 62 through...
Point of
Oh, another
vote.
Well, let's get that done. Submitted to clauses 62 through 112. Do we have unanimous consent to group them? Yes. Shall clauses 62 through 112 carry? Yes. Merci. This brings us to clause 113 and NDP 4. Mr. McGregor.
Sorry, Chair, you said NDP 4?
Yes.
Yes. Okay. All right. So this was an amendment to the bill that was brought forward by my colleague Jenny Kwan, a member of Parliament for Vancouver East. So amending on page 75, line 25, and just further clarification on part F of the definition of political or governmental process. So basically, although the Director General who appeared from Public Safety Canada said it was their interpretation that leadership contests could be or would be included, Ms. Kwan felt it was appropriate to further clarify this just for a little bit more specificity in the law.
Thank you, Mr. McGregor. So if NDP 4 is adopted, BQ2 cannot be moved due to a line conflict. Okay? Is there any discussion on NDP 4? Mr. Gahir.
Thank you, Chair. I'd like to just ask the officials that even without this amendment itself, we know that would foreign efforts aimed at influencing the appointment and elections within a political party, including leadership contests, would they be captured under this act?
The intent of the legislation was to be fairly broad with political processes, and it is our interpretation and intent that those things would be captured under the current drafting of Bill C-70.
Any further discussion? Mr. Chong.
Yeah, Mr. Chair, we'll support this amendment because it provides greater clarity of what officials have said are the intent of the bill's clause.
Discussion. Mr. Gahir.
Thank you, Chair. So I believe that the amendments offered to the Security of Information Act also defined a political or governmental process using the unamended definition. So can the officials confirm that that is the case?
Thank you for the question, Chair. It is true that there is a similar definition within Section 20.4 at Clause 113 of the Act, and so the effect of the amendment would be to change the definition in one place in the Act and not change it in the other place in the Act.
If I could just ask a follow-up question.
Mr. Gahir.
So what are the consequences of having those two different definitions?
It's difficult to predict definitively, but there is the possibility that a judge might determine subsequently that this was done intentionally and that a different interpretation should be applied to the two different definitions provided to the same term.
Any further discussion? Ms. O'Connell.
Thank you, Chair. Just following up on that, then, if a judge could determine that there are two potentially contradictory definitions, then they could rule one in order and one not? And does this not risk, and because of the constraints we're under this committee, we can't go back and create the matching definitions in SOIA, is that correct?
Sorry, I didn't intend to cut anyone off, Chair. The concern is that in a subsequent interpretation of the term, that a court or the lawyers involved don't have time to consult this record, which would show that the intention is to create a non-exhaustive list in both places in the Act that captures leadership contests and nomination contests. That is the risk.
So you feel comfortable that the language as is, unamended, covers the additional wording, like things like appointments, elections within a political party, including leadership contests, that is part of the existing Act without defining it so that there wouldn't be confusion without having the same defined language in the other part of the Act?
Thank you, Chair. The intent in the offense provision and in the registry offense provision is the same, which is to create a non-exhaustive list that captures nomination contests and leadership contests, as well as those other internal mechanisms and procedures within the democratic aspects of a political party. But the effect of this amendment would simply clarify that leadership contests are included in the registry portion of the bill. It would not similarly clarify it in 20.4, the proposed 20.4.
Thank you. So, Chair, with that being said, I think if the intention of the Act are to include these things, which I feel confident it has been, I worry that this amendment, and we then can't support it, this amendment would cause confusion because we are constrained at this committee to be able to go back and create the the same language in the rest of the act. So I feel comfort in all of these political activities that are outlined in the amendment are already covered, and I don't want to cause confusion of the implementation of this act, so we can't support it. Thank you, Chair.
Thank you, Chair. Mr. Scrivens, am I correct in, like, these are two very different acts that serve different purposes? I mean, Part 4 of this bill is it's enacting a brand new act. It's setting up a registry, which I think is the transparent foreign interference that is happening, whereas these important amendments to the SOIA are really, I think, attempting to go after the more clandestine, deceptive methods of foreign interference. So am I correct that, these acts are serving different purposes? Would they ever cross each other in any way to cause that kind of confusion, since they're going after two very different things? One is very public, a public registry. One is under serious offenses under the SOIA.
Thank you for the question. It's our view that we can't rule out a circumstance, given that the registry creates criminal offenses. Cannot rule out a circumstance where 20.4 of the proposed 20.4 of the SOIA would overlap with a set of circumstances that would give rise to offenses under the registry proposal.
Any further discussion? Mr. Chung?
Yes, is the Security of Information Act definition, was that contained in Part 2 of this bill in front of us, Mr. Chair?
Yes, it is.
And what I remember our witness referring to a particular clause, 20, I believe it was. Well, I'm trying to find it in the bill. That's page 30. Okay. Mr. Chair, when I read that section, on page 30, I don't see any reference to a leadership contest.
Let's carry on this discussion after we have a vote. So. Your discussion.
Yeah, I just wanted to understand whether on page 30 in the definition of political or governmental process, Part F, which refers to the nomination of a candidate, would include the selection of a leader of a registered political party.
Thank you, Chair. I think the best way to answer this question is to indicate that where the clauses use the term includes, the following examples are intended to be examples of circumstances where the offense applies, but the intention is to indicate a non-exhaustive list of examples, and the same framework was adopted for the registry as well.
Okay, Mr. Chair, we're armed with that information, that clarification. I'm prepared to defer to officials on this and their expertise. Thank you.
Can we just suspend for 1 minute?
Sure. We'll suspend for a brief time.
Unanimous consent to withdraw NDP 4.
Do we have unanimous consent? Yes, we do. Okay. That brings us to BQ2. Since NDP 2 was not NDP 4 was not adopted, we can now move BQ2. Mr. Villemure, if you please.
Monsieur le Président, j'aimerais déposer.
I'd like to move Amendment BQ2, which is in a similar vein to my previous colleague's amendment. The purpose of the amendment is to include the election platform of a political party by replacing line 25 on page 75 of an electoral platform by a political party, etc., etc.
Sir, is it Mr. Gahir?
Thank you, Chair. So the amendment would alter the definition of a political or governmental process under the proposed act to allow the governor and council to set out additional processes in this definition through regulations. So it's unclear what will be set out through the regulation that wouldn't already be captured through the broad and non-exhaustive definition of political or governmental. But I'd like to get the officials' word on this.
May I ask you to repeat that, if you don't mind, Chair?
That was quite fast. I'll slow it down. So this amendment, as we know, would alter the definition of a political or governmental process under the proposed act to allow the governor and council to set out additional processes in this definition through regulations. And then we know that, as drafted already, political or governmental process is non-exhaustive, and it's intended to include any political or governmental process. So to me, as far as I can read it, it's unclear what would be set out through regulations that are not already covered by this broad language.
Thank you, Chair, for that question, and thank you for the member for repeating it. The list is, as my colleague here mentioned, it include a non-exhaustive list and is quite broad in terms of government and political process. And a commissioner would be free to interpret that in a specific context. And so the intent was to create a list that was non-exhaustive. That's what's included here, and I think it includes a lot of issues that would be captured within a government political process.
Discussion on BQ2. Seeing none, shall BQ2 carry? No. I think that's a no. This brings us to NDP 5. Mr. McGregor.
Thank you, Chair. I think this is a great segue after we just talked about the benefits of having harmony between the SOIA and Part 4 of this Act. And so essentially what I have asked the amendment drafters to do was to take the definition of public office holder, which is on page 30 and 31 of this bill. That is a definition which is being added to the Security of Information Act, and I have asked them to include those exact same components into this new act so that it would basically be exactly in harmony with the SOIA.
Very well. Any discussion? Seeing none. No, I apologize. Ms. O'Connell, go ahead.
Thank you, Chair. I can't see witness names because my eyes are going, and now you can't see me. So thank you, Chair. I'm just a question of this to officials. Why was the reference to the Lobbying Act specifically made? what benefit does it have? And specifically, are there unintended consequences of this amendment?
Thank you for that question, Chair. The reason that the reference in the legislation used is the Lobbying Act is because the registry does have some similarities to the intent of the Lobbying Act, and by referencing the definitions in the Lobbying Act, it allows us to align with that piece of legislation. But also, if the Lobbying Act changes, then automatically the definitions of public office holder in FIDA would change because it's being done by incorporation by reference. And so it would always be up to date. And so the amendment would lay out similar or the same language, but if the Lobbying Act were to be amended, then the FIDA and the Lobbying Act would be different and could create some confusion for individuals who might have to register in both under both pieces of legislation.
Thank you. So then if the intention is just to keep the Lobbying Act language, but without having to come back in the event it changes, I'm more comfortable with leaving it as a reference to the Lobbying Act so that this bill doesn't become outdated the second the Lobbying Act changes. And I would be, so I accept and appreciate the intention to kind of put it, the amendment to put it out there very clearly, but I do worry that the timing of, one change to one piece of legislation and then a review of another, I would rather keep it to allow that it can be automatically in alignment. I don't know if there was anything else that to our officials that they wanted to add on this.
Yes, if I may, just to point out, part of your question was the impact of the amendment. It would misalign, or it would misalign the coming into force of the provisions in the definition, because we've broken out, or the legislation breaks out, the coming into force of different parts of the law as it applies to PTs and Indigenous governments, and so the amendment would create confusion with that and impediments.
Now I remember, thank you again, Chair, I remember that specifically in this legislation there is coming into force that is different for Indigenous communities, so that there is an opportunity to further consult and make sure that there's an understanding of how legislation might impact them and how we can work and make sure that we have proper consultation. Are you suggesting that then this amendment would put all of the coming into force under one regime and not have a separate for Indigenous consultation?
No, I think, Chair, what I'm suggesting is that because of the coming into force, the reason for the mismatch or the opportunity to bring into force Indigenous application later was to allow for consultation. And because of differences in governments and how the definition of public office holder may apply, we wanted the benefit of having those consultations so that we can align the coming into force properly and the application to Indigenous partners properly.
I see. So the coming into force would be part of that consultation for the Indigenous piece. Okay, thank you, Chair. For that, I feel like I'd be very comfortable if it's directly in line with the Lobbying Act, and as that gets updated, so does this portion of the bill, and I'm comfortable with that. Thank you, Chair.
Yeah, two things. I mean, we just had a big conversation about how it was important that this new enactment lines up with definitions in the SOIA, so now we're having a completely different rationale argued by my Liberal colleague. And second of all, if you look at the existing Lobbying Act, I'm just bringing it up here, Section 2.1, because that is what is referenced, it does not appear that there is any mention of MP's staff, whereas my amendment is seeking to specify that specifically. It says in the new B, members of the legislature of a province or persons on the staff of such members. So, I think we just had an argument regarding the previous one of the previous amendments that we should respect harmony with the Security of Information Act. I believe this is trying to bring the bill in that same spirit.
Any further discussion? Seeing none, shall NDP 5 carry? So that brings us to NDP 6. So if NDP 6 is moved, NDP 7 and BQ 3 cannot be moved as they are identical. Mr. McGregor, did you wish to move NDP 6?
Yes, I do, Chair. So I know, thanks to our officials, because I know in witness testimony when I had asked them about this, they had said that they did interpret provincial or territorial political or governmental processes to include municipalities. I appreciate that, but I'm always a favor of specificity where we can bring it in the law. And again, this is bringing it in harmony with the Security of Information Act, which I think does make specific reference to municipal government. If you just bear with me, if I go back to the amendments. Yeah, I do believe there is, yes, there is a reference. If you look at the bottom of page 31 of the bill, it does specifically reference in the application part municipal, political, or governmental processes. So this is bringing this part 4 into harmony with what's going on page 31.
Thank you, Chair. As I continue on my journey to become a licensed lawyer in Canada, I've actually just recently done my constitutional law exam. And if I remember my lessons correctly, municipalities are constitutionally actually creatures of the province itself and exercise all of their authority through provincial devolution. So my question, I guess for the officials is, can you confirm that even without these amendments, that the political or governmental processes of municipalities will be covered?
Yes, Chair.
Ms. O'Connell? Oh, I'm sorry. Go Mr. McGregor, then Ms. O'Connell.
Thank you for that answer. May I ask why then the amendments to the Security of Information Act felt it necessary to include a specific reference to municipal political government processes when, if they are in fact a creature of the province, you already have it covered in B? I'm just wondering.
Mr. Scrivens?
The intention there was to be as specific as possible because at the time we were specifying a level further, which was at the school board level, which is now incorporated in a secondary definition. But it's a bit technical and complicated, but in attempting to assert a very broad scope for that provision that included school board elections. The intention was to specify all levels and orders of government down to school boards.
Chair, and the one part I liked about Mr. Scriven's answer was an attempt to be as specific as possible. I think that's great, and that's what we should be attempting to do here.
McGregor, any further discussion? Ms. O'Connell.
Thank you, Chair. I believe, or maybe three to the officials, that one of the issues with this was the fact that there is no, is it the coming into force clause for something referred to as B.1? So even if we make that amendment, the problem is the fact that B.1 then isn't referenced.
So thank you, Chair. So there are three coming into force provisions, one for A, one for B, one for C. And there are three different. If you decide to add B.1 as a separate category, there is no equivalent coming into force provision for B.1.
We just added in B, provincial, comma, territorial, comma, or municipal, that the coming into force issue would not be an issue.
That's
and would
correct.
do what the amendment of Mr. McGregor is.
That's correct.
So, Chair, I don't know if this will be ruled in order or not, but I would like to make a sub-amendment that we delete B.1 and instead move within B, provincial, comma, remove or, territorial, comma, or municipal, and then continue with the political or governmental processes. And I have extra copies if anyone needs them in both official languages.
Could you distribute that, and we will suspend, because it's meeting suspended. This amendment would have been required to be, it's an amendment, not a sub-amendment, because it amends, so it's not in order according to our rules at the current time. All right? So, Mr. McGregor, go ahead.
Are we, as a committee, allowed to challenge the chair on that?
You can always challenge the chair. But this change basically would add another B to the paragraph, to the text. So you'll have two Bs. It makes the bill unintelligible, right? This is my advice. So, Mr. McGregor, are you done?
I'll let Mr. Chong.
Mr. Chong, go ahead.
So, Mr. Chair, so in other words, what you're saying, we have the option to negative NDP 6 and then consider another amendment, which has been essentially proposed by Madam O'Connell.
Except we're not allowed to do amendments. We can only do amendments to the bill that were submitted prior to 4 p.m. on Friday. Of those amendments that were submitted prior to 4 p.m. on Friday, we can do sub-amendments. This change would require its own amendment, and therefore it's excluded by what we're allowed to do under the terms of the House order. Potentially, though, we should make a list of these things and deal with it at report stage when it gets back to the House.
And Mr. Chair, just to another point of order, NDP 7 appears to be exactly the same as NDP 6.
Well, NDP 7 cannot be moved, nor can BQ 3 because NDP 6 was moved.
I see. There was just, okay, I understand now. Understood. Thank you, Mr. Chair. So there's no way to amend NDP 6 in the way that was suggested by Madam O'Connell?
It appears not, because it says to take this line of the act and substitute this text what Ms. McConnell's change is trying to do is add something to the previous line of text. Right? And we're kind of caught between Ms. O'Connell, please.
Chair, could we ask for unanimous consent to accept this as a sub-amendment?
You can ask, but the chair was going to rule it as out of order, so you'll have to override the chair.
So, Chair? Chair.
There will be the repetition of text in the bill.
And it will produce a repetition of text in the bill, right?
Chair, in all seriousness, I understand and recognize the importance of the House motion, but I think it's silly that we have an opportunity to make legislation better in this committee, and I think we have some consensus in how to do so without the unintended consequences of a coming into force issue. So, I mean, yes, we can do it at another stage, but I think if there is will amongst this committee, and while I respect the law clerk's ruling and your ruling, I think, these aren't normal constraints we're under, and we have an opportunity to actually just make the bill a little bit clearer, and if we have support, I think we should do so.
Let me pause and talk to my friend here. Mr. McGregor, go ahead.
So with great respect to you, Chair, because I understand the confines you find yourself in, I would move formally to challenge you, and as a committee, the motion would be to accept the amendments as proposed by Ms. O'Connell. This is a minor fix, and really it lends itself to making the bill more clear.
Let's make this proper. So Ms. O'Connell's request is to amend the previous line as stated. I rule it out of order. You're challenging me. Okay, the question then is, shall the decision of the chair be sustained? I'm outvoted. Okay. So,
There's debate on that.
so is there debate on that change? No debate? Are we clear on what we've done here? Right? Okay.
If you
All
like
right.
a suspension, we're just explaining to them
Short time while we get squared away up here. Okay, I think we have come to a resolution. Ms. O'Connell.
Thank you, Chair. And in effort to speed this along, I'm going to withdraw my amendment.
Okay, we need unanimous consent. Do we have unanimous consent? Yes, okay, go ahead. Mr. McGregor.
And I'm going to ask for 2 unanimous consents. The first unanimous consent is I ask to withdraw my amendment.
Unanimous consent? Yes, okay.
And my second ask for unanimous consent is that we amend, I think it is it line 16? I'm just looking at the clerks I'm making sure I've got it correct. Line 16 on page 76.
I'm going to need a copy of that. Could you email it? Do you have any?
Well, we've got it all kind of spelled out here.
Okay,
I'm just going to basically read out the sub-amendment and amendment together.
Well, we'll try that and see how far we go, okay? Go ahead.
Okay, so replacing lines 16 and 17 with B, provincial, comma, territorial, comma, or municipal, political, or governmental processes.
Territorial, comma, or? Okay.
Provincial, comma, territorial, comma, or municipal or governmental processes. I'll just need them to repeat that.
We're good?
If you could just repeat that again.
Could you repeat that one more time?
Certainly. So replacing line 16 and 17 on page 76 with the following: B, provincial, comma, territorial, comma, or municipal, political, or governmental processes.
Okay. I think we're clear on that? Yes? Do we have unanimous consent to take this action? Yes, we do. Over the ruling of the chair, and all. Okay. So let us carry forward. So I think what this means is that NDP 7 and BQ 13, as we said before, can't be moved, I believe, right? If NDP 6 was moved, then NDP 7 and BQ 3 could not be moved because they were identical. They're no longer identical, so I'm not sure whether.
That's right. That's right. So they can no
longer be moved because of conflict now, right?
Yeah.
Okay. All right. So they can no longer be moved. So that brings us to BQ4. Monsieur Villemure, s'il vous plaît.
Mr. Chair, I'm pleased to move BQ4, the purpose of which is to add Crown corporations and universities as suggested by Mr. Fadden, the former CSIS director, and Ms. Long. I've forgotten the name of the diaspora. It was Hong Kong Link or something of the kind. The intention was to ensure that the Act would apply to those institutions because they are places where foreign interference occurs currently.
Okay, is there any discussion? Mr. Gayer.
Thank you, Chair. We think this might be an overcorrection beyond what the position of the government, but I'd like to ask the officials on their position.
Thank you, Chair, for that question. The proposed amendment in relation to D, the political or governmental process of federal or provincial Crown corporation, the intent and interpretation is that the current definitions in the Act, in Bill C-70, include Crown corporations, and so our interpretation, obviously, which would be subject to the Commissioner's interpretation, is that those are already included in the definition. In terms of political or governmental processes of a university or government research center, I would say that the proposed amendment goes beyond what we intended in terms of the transparency registry. It was intended to go out to increase transparency in activities related to government and political processes, whether it be the federal, provincial, or territorial or indigenous government, and would go far beyond that. I would say that in terms of research, in terms of universities, again, it would significantly expand the scope, and I would say that there's already a number of initiatives that are in place in programs such as the Safeguard and Science Initiative, the outreach program at the service, and new national security guidelines for research partnerships that are aimed at tackling the problem of research security. And the transparency proposals here as they relate to the government would be more difficult and very difficult to apply in the context of a university, because it would target the government and political process of the university, which is very different than the government or political process of a government.
Oui, Monsieur le Président, pour ma...
Well, Mr. Chair, overall, Bill C-70 that we're considering is attempting to fix a problem. And that problem, well, it's difficult in terms of enforcement in some cases, but the fact remains that universities that receive federal funds are currently the target of foreign interference, despite the programs that Mr. Bilodeau listed. So if the intention of the bill is that one needs to be more transparent in order to reduce or eliminate foreign interference, well, it's a tad ambitious, but the fact remains that if we want to reduce the harms of foreign interference, well, one cannot escape the fact that the universities are being targeted.
Thank you, sir. Any other discussion? Shall BQ4 carry? No. Negative. Okay. That brings us to BQ5. Monsieur Villemure.
Thank you, Mr. Chairperson. I'm pleased to move BQ5. And I'll be concise. It's the double registration amendment that we discussed a couple of months back. You know, Mr. Chair, it's perhaps not conventional, and I understand that. But when you want to establish a link between both parties, it's wise to identify the two parties in question in the first place. Now, I know that for some orders, the measures won't be the same. For example, at a university, it might be different, but when it comes to a public office holder, the individual who would be on the registry as a foreign principal, well, that's the link that we're trying to establish to determine the legitimacy or otherwise of the relationship. Now, I don't know who the other party would be, but it's difficult to make that link with the foreign principal otherwise. So here's what I'd say right off the bat. It's been told to us in the committee, good idea, bad idea, on the fence, a lot of different opinions. But it's not one of the best practices per se to have having a double enrollment or registration is a guarantee of being able to identify a source in a more certain manner.
To interrupt you after you moved, so that I have to make a ruling on this. So Bill C-70 amends several acts and enacts the Foreign Influence Transparency and Accountability Act. The bill provides that persons who enter into an arrangement with a foreign principal under which they undertake to carry out certain activities are required to provide the Commissioner with the information specified in the regulations. The amendment seeks to add that even if no arrangement has been entered into, any individual other than a public office holder must file a return with the Commissioner if that individual receives a communication from a foreign principal requesting that the individual take certain actions. In the opinion of the Chair, the amendment adds a new concept that is beyond the scope of the bill as adopted by the House at second reading. Therefore, I rule the amendment inadmissible. Go ahead, Ms.
J'aimerais respectueusement.
Well, respectfully, I'd like to challenge your decision, Mr. Chair. Absolutely.
The question is, shall the decision of the chair be sustained? I think that was on division. Shall we have a recorded vote? Yes, please.
Mr. Biddle,
Yes.
Mr. Gahir,
Yes.
Mr. McDonald, Ms. O'Connell,
Yes.
Ms. Zaid,
Yes.
Mr. Caputo,
Yes.
Mr. Chong,
Yes.
Mr. Shipley,
Yes.
Monsieur Villemur.
No.
Mr. McGregor.
No.
Oh, Mr. Motz, sorry.
Yes.
Very sorry. Mr. McGregor? Six yeas, 4 nays.
Okay, decision is sustained. That brings us to BQ, sorry, that was
That was BQ5.
That was BQ 5. So that brings us to BQ 6. So if you, Monsieur Villemur, if you move it, but I also have to rule on this one as well. So. So Bill C-70 amends several acts and so on and so forth. Once again, the amendment creates a new concept that is beyond the scope of the bill as adopted by the House at second reading. Therefore, I rule the amendment inadmissible. Monsieur?
I'd like to challenge your decision, Mr. Chair.
Shall the decision of the chair be sustained? Do we need a recorded division? Oui?
Mr. Biddle? Yes. Mr. Gahir?
Yes.
Mr. McDonald? Ms. O'Connell?
Yes.
Ms. Zaid?
Yes.
Mr. Caputo?
Yes.
Mr. Chong?
Yes.
Mr. Motz?
Yes.
Mr. Shipley?
Yes.
Monsieur Villemur?
No.
Mr. McGregor?
Thank you.
So, 9 yeas, 2 nays.
Merci. That brings us to BQ 7. Mr. Villemur, would you like to move this? And also,
No.
No? You're not? Okay. That brings us to BQ 8. Did you wish, Mr. Villemur? I will also have to.
Oui.
So, did you wish to move BQ 8? Yes? Yes. So same problem. In the opinion of the chair, the amendment creates a new concept that is beyond the scope of the bill as adopted by the House at second reading. Therefore, I rule the amendment inadmissible. Challenge? Absolument. Let's do a recorded division, please. Shall the decision of the chair be sustained?
Mr. Biddle?
Yes.
Mr. Gahir?
Yes.
Mr. McDonald? Ms. O'Connell?
Yes.
Ms. Zahid?
Yes.
Mr. Caputo?
Yes.
Mr. Chong?
Yes.
Mr. Motz?
Yes.
Mr. Shipley?
Yes.
Monsieur Villemur? Mr. McGregor?
No.
9 yeas, 2 nays.
Merci. That brings us to BQ 9, which I'll give you forewarning. I'm not going to rule inadmissible.
Merci, Monsieur le Président.
Yeah. To rule on it until it's moved. It's kind of a gotcha, really. But anyway, go ahead.
Je vais présenter le BQ.
I'll present BQ9 if I may, Mr. Chairperson, at this stage. Absolutely. Several witnesses, including Dr. Chalbert, Mr. Junot Cassier, and Mr. Fadden, told us that it was wise, in fact indispensable, that public office holders benefit or be subject to a cooling off period for a 3-year period. Now, The purpose is to prevent former office holders to enter into arrangements with foreign principals. The goal is clear, and we want to ensure that newly elected members can benefit from this as well. We think it's a very wise amendment that's in line with the public interest, and that is why we've moved BQ9, and it's up for debate.
Thank you, Mr. Villemure. Ms. O'Connell, please.
Thank you, Chair. Well, I think the intentions are good in the sense that if there was a foreign state trying to influence Canada and then a former public office holder went to go work with them, that would be problematic. The problem is this amendment is quite broad, and it just says a former public office holder cannot enter into an agreement with a foreign principal. What if that arrangement was something with one of our allies, with, promoting democracy or doing work that I think many public office holders and the experience in Canada would be actually quite helpful. So there's a distinction between a foreign agent or influence type work, and then a difference between doing also important work that promotes actually democracy around the world, and this does not distinguish the two. The other concern I have is it's just too broad and doesn't deal with it. And should an individual, whether they are a public office holder or not, become or enter into an arrangement with a foreign principal that is to impact or advise on behalf of that foreign principal, they'd be subject to the foreign agent registry and would have to be identified on that anyway. So I feel like that transparency piece deals with, again, I think the intentions are good. It's just the drafting of it, I think, is too broad to allow for the distinction, and I think the registry itself would then allow for the disclosure of that individual and any sort of foreign principal arrangements. So we can't support it as drafted.
Thank you. Mr. McGregor, go ahead.
I think this is a solid amendment. I won't go over the reasons Mr. Villemure said, but the NCCOP report that was tabled last week did talk about how some public office holders are expecting a quid pro quo arrangement, and I think if we're going to nip that problem in the bud by putting it in the law that a public office holder cannot enter into an arrangement with a foreign principal for this specified period of 3 years, that's a good proactive step here. It shows foreign principals that your investments are not going to bear any fruit. Mm-hmm. So again, we have to look at the seriousness of the problem, and I believe it is incumbent upon this committee to explore all of the legislative options at our disposal. So I will be happily supporting this amendment.
Thank you, Mr. McGregor. Is there any further discussion? Sure. Mr. McDonald.
Can we ask the officials if there's any consequences or complications in adopting this as is?
Thank you. I think one of the things that when we looked at the amendment that stood out is there are other already provisions in the Conflict of Interest Act, and so we would have to explore the consequences of this or the interactions between a prohibition and the conflict of interest legislation. There are also questions about whether the registry, by requiring the transparency, is sufficient to shine a light, which is what the transparency registry is about, right? It is about increasing transparency of that influence in Canada. And so those are the two things that I would point out, but definitely the interaction between this and existing legislation, whether it's a lobbying act or the Conflict of Interest Act, would be worth exploring.
Mr. Villemure.
Thank you for the clarification. I think that the very nature of the threat that we're discussing today warrants the fact that, or justifies the fact that, yes, it will be complex, yes, it will be difficult, and yes, we have to go ahead with it nevertheless. These are not unprecedented cases that are being referred to. As my colleague from the NDP said, we're talking about foreign powers that are currently investing in people in order to do X, Y, and Z. And it strikes me that the threat level of the threat itself, speaks for itself. And are we going to leave some wiggle room for interpretation? Yes, to some extent, but having legislation that in this manner is not a good idea.
Any further discussion? Shall BQ9 carry? BQ9 does not carry. That brings us to NDP 8. Mr. McGregor, please.
Thank you, Chair. I'm just going to get to the correct page here. Yes. So this was an amendment drafted by my colleague, Ms. Kwan, and her notes here were just referring to the fact that the China Strategic Risks Institute says that the new act being created in Part 4 does not provide the relevant authorities with a mechanism to notify affected parties of a registration requirement, nor to warn the public about foreign agents of concern. Such proactive mechanisms could be developed, modeled on the information notices and transparency notices within the Australian model. And that's essentially what this new 8.1 is designed to do. So I will leave it at that.
Thank you. Any discussion? Ms. O'Connell.
Thank you. When I first read this, I had some concerns about the automatic kind of listing of relatives, and relatives are loosely designed or defined, and acquaintances. And given some of the foreign interference that has happened, there could be unintended consequences of an individual having nothing to do with any attempts of foreign influence, but their relative would then be kind of list them, so to speak. That was my initial concern, but perhaps I'll turn to officials to for one, is that kind of reaction how you would read it? And two, do you have other concerns in regards to that connection? I know Mr. McGregor mentioned the Australian model, but there are differences, and I think it's around the defining of some of this. And so, again, I just have some concerns, especially when we heard testimony about individuals being intimidated, and I think it's not the intention of the bill to then pre-associate relatives just by nature of being related to another individual. Could I maybe have some clarification? Thank you.
Thank you, and thank you for the question. So we did note, Chair, the connection to the Australian model. We would just say that the difference in the Australian model is that foreign government-related entity and foreign government-related individual is defined in the Australian model, where it is not currently in the definition in the proposed act. The definition of foreign principal is specific to foreign state, foreign power, foreign entity, and foreign economic entity. This would provide a lot of discretion to the commissioner to apply what they consider to be related to in terms of the extent of that relationship in the application. And then I think to the intent of the powers being afforded to the commissioner in the proposed act, it would also allow for the issuance of notices, so already without specifying the related provision.
Thank you for that. But is my understanding correct that the notices could be automatically applied to a relative? And again, the definition of relative, it could be a cousin, for all we know, could automatically be given? Because that raises all kinds of fairness questions.
Absolutely. I think that it is possible that a commissioner could interpret this very broadly and apply the designation to, for example, persons related by blood, friends, acquaintances, individuals who fall within the definition of foreign principal, beyond what falls within the definition of foreign principal. And the intent of the Act is certainly to work towards transparency around protecting individuals who may be most subject to that level of influence.
Thank you.
Thank you. Is there any further discussion? Seeing none, shall NDP 8 carry? No. This brings us to NDP 9, and I will have to rule on this afterwards. Mr. McGregor, if you wish to move the motion.
Thank you, Chair. And I know there were some discussions with colleagues, so I am expecting a sub-amendment. But before we get to that stage, I'll just say quickly that we did hear from a variety of witnesses who expressed a desire to see the appointment of the commissioner to be a little bit more detached from relying too much on the governor and council. And so essentially, this is providing a process for it's the same process as would be in place for the appointment of the Auditor General. And I would note that there's some remarkable similarity with CPC 3 right behind it. So I'll leave it at that and see what my colleagues have to say.
So the bill provides for the appointment by the Governor and Council of a Foreign Influence Transparency Commissioner. This amendment provides that the Governor and Council cannot make the appointment without the approval of Parliament. In the opinion of the Chair, the amendment creates a new concept that is beyond the scope of the bill as adopted by the House at second reading. Therefore, I rule the amendment inadmissible. Mr. McGregor.
I wish to challenge the Chair on that.
Absolutely. Shall the decision of the Chair be sustained? I think we need a recorded division.
Okay,
I'm sorry?
go ahead. You were in the middle of a vote. I can't do anything now.
Shall the decision of the Chair be sustained?
Mr. Biddle?
Yes.
Mr. Gahir?
Yes.
Mr. MacDonald? Ms. O'Connell?
Yes.
Ms. Zahid?
Yes.
Mr. Caputo?
No.
Mr. Chong?
No.
Mr. Motz?
No.
Mr. Shipley?
No.
Monsieur Villemur?
No.
Mr. McGregor?
No.
Five yeas, 6 nays.
So the Chair is overruled.
Chair, I ask we suspend
So-
for,
Okay,
can I ask for a suspension, Mr. Chair?
Yeah, I'll just mention that, so if NDP 9 is adopted, CPC 3, BQ 10, and BQ 11 cannot be moved due to a line conflict.
Sorry, Chair, would you be ruling CPC 9 out of order as well? Or 3, sorry, CPC 3?
Yes, I would.
Okay, can we
If it had been
suspend,
moved.
please?
But anyway, we've been asked for a suspension. Do we still need that? Okay. We are once again resumed. It's an interesting process we've got going here. Anyway, I will recognize Mr. Chong for a sub-amendment on NDP 9.
Thank you, Mr. Chair. I am moving the following sub-amendment after discussions with members from all the recognized parties on this committee. I move that we strike the words "by commission under the Great Seal" and the words contained in G by replacing line 22 on page 78 with the following: on address of the Senate and House of Commons.
Okay.
If we could just have a moment to see how it affects the bill, just to
So let's pause briefly and let legislative analysts see how it affects the bill, and then they'll advise. And we go once again to Mr. Chong.
Thank you, Mr. Chair. After consultations with the procedural clerks, the legislative clerks, I've been advised to seek unanimous consent to withdraw my sub-amendment and re-present the amendment, which has the sub-amendment in a different form that would have the same effect of the sub-amendment that I propose to withdraw.
So let's first withdraw the sub-amendment. Do you have unanimous consent to withdraw Mr. Chung's sub-amendment?
Yes.
Yes.
Okay, Mr. Chair, I propose the following sub-amendment, that the following words be struck from the amendment. 9.1, the Governor and Council is to appoint by commission under the Great Seal an individual. And G, by replacing line 22 on page 78 with the following on address of the Senate and House of Commons.
Good. Okay, thank you. Is there any further discussion on Mr. Chung's sub-amendment? Ms. O'Connell.
Sorry, I just want to get clarification. If all of 9.1 is removed, then it would mean that it's not a governor and council appointment?
Mr. Chair, I can clarify that. That is not correct. The existing bill in front of us on page 78, on line 4, the language would remain the same, which reads as follows. 9.1, the Governor and Council is to appoint an individual to be known as the Foreign Influence Transparency Commissioner to be responsible for the administration and enforcement of this act. So that would remain as it is, unamended.
Okay. And it's just the amendment here we're dealing with then that is being changed. Okay, thank you.
We're good? Okay. Any further discussion? Shall the sub-amendment carry? Sub-amendment carries. That brings us back to the amendment as sub-amended. Is there any discussion on the amendment as amended? None? So shall NDP 9 as amended carry? Done. So that would leave CP3 up.
NBQ 10 and BQ 11.
So CPC 3 cannot be moved, and BQ
BQ 10 neither.
BQ 10 cannot move, and BQ 11 can, right?
BQ 11 can be moved now that.
Okay. This brings us to BQ 11. Monsieur Villemure, allez-y.
PQ 12, Monsieur le Président.
BQ 12, Mr. Chair, you're mistaken, I believe.
PQ 11, je m'excuse, Monsieur le Président.
Oh, sorry, no, BQ 11, you're right. It's about the commissioner's revocation. We'd like to make an addition such that the Senate and House of Commons be part and parcel of the revocation process. If you read the amendment, and sorry, I'm just putting my finger on it, it will amend C70, 13, page 22, 78, on the address of the Senate and the House of Commons. So essentially we're adding the Senate and the House of Commons.
Sorry, I was focused on something else here. Would you say that again,
Sans
please?
problème.
No worries. So we'd like to make an addition, 2178, which would read as follows. The Governor in Council at the address of the Senate and House of Commons. It's an addition in terms of we're adding the Senate and the House of Commons.
So debate, there can be debate on that.
Yeah. Is there any discussion? Mr. McGregor?
Yeah, so I'm just curious, when it says at any time on address of the Senate and House of Commons, I'm not sure of the word address there in the English part. Is it at any time on the recommendation of the Senate? Like, it's confusing to me. Can you explain?
I think that's legal talk. Mr. Chong.
Yes, I can clarify what that means. That would mean that in order for the commissioner to be removed, they would have to be removed after an address, on address of the Senate and House of Commons, which means that a resolution of the House of Commons and a resolution of the Senate would have to be adopted in order for that person to be, for the commissioner to be removed from office.
Very well. Any further discussion? Seeing none, shall
BQ 11.
BQ 11 carry? No.
I hope that was the right interpretation. Sorry, that was my inside voice.
Okay,
We're now on NDP 10.
so BQ 12 can't do it?
It can't be moved because BQ 8 wasn't
Okay.
adopted.
Arrived at NDP 10. Mr. McGregor.
Yeah, thank you. So this is an amendment to remove the administrative monetary penalties from the bill. So deleting from line, hold on, let me get the page right here. Deleting from line 22 on page 81 to line 19 on the following page, or sorry, no, to line 19 on page 83. And the reason for this is Ms. Kwan believes that there were some foreign interference activities in relation to her 2019 campaign. She did file complaints with law enforcement. And I think the outcome of that was that Elections Canada decided not to fully investigate and instead opted for an administrative penalty of I think $500. So she's not really interested in administrative penalties being assessed for what I think we can all agree is quite serious. And so it's removing the administrative penalties but keeping the more serious punishments in place.
Mr. Gahir.
Thank you, Chair. So, this amendment would reduce the tools that are at the disposal of the Commissioner to administer under the proposed Act. As it's currently written, the Act has 3 levels of scalable enforcement mechanisms, from issuing notices to levying fines, and then finally referring the case to law enforcement authorities. And removing this would remove that middle step, and it would be issuing notices all the way to criminal prosecutions, and there's no intermediate step in between. But I'd like to hear what the officials have to say on this step as well.
Thank you, Chair. The bill was put forward in a way that the Commissioner would have the maximum discretion on which tools to use to address specific instances of non-compliance. And there's a recognition that not all non-compliance deserves criminal punishment, but also a lot of non-compliance doesn't deserve just a notice. And having administrative monetary penalties gives that intermediate step, but it also issuing administrative monetary penalties, by their definition, are meant to encourage compliance and deter non-compliance, and so they're an important tool in doing that. And in any given situation, if the Commissioner believes in their discretion that a particular breach of the law requires more severe consequences, the Commissioner can refer the matter to a police of jurisdiction for investigation, who could then move forward with criminal charges if they deemed that appropriate.
Any further discussion? Seeing none, shall NDP 10 carry? NDP 10 negatives. Okay. PQ 13 can't be moved because other things didn't get moved. We come to NDP 11. Mr. McGregor once again.
Thank you, Chair. So we're now going to page 85. And NDP 11 is going to replace line 2 on page 85 with what you can see there, and then by adding after line 20 on the same page what you can see there. And I just want to make sure I've got it all. Yeah. So this amendment provides for the naming of foreign principals without broadly specifying a list of countries. It can be a tool that's used sparingly, an enhanced tier that allows the option of requiring increased reporting and disclosure requirements, where a mere registration is not enough to mitigate negative risks of foreign influence from hostile states. If it's used appropriately, the enhanced tier could overcome some of the problems encountered by Australia's country-agnostic version. For example, the Australian Strategic Policy Institute has pointed out that the activities of the United Front Work Department of the Chinese Communist Party is entirely missing from the FITS registry, as well as the role played by the Confucius Institutes at Australian universities. So I think, overall we're respecting country agnostic registry, but just providing, a specific tier.
Discussion? No discussion?
I have a question.
Mr. Chong.
I'd like to hear from officials whether or not the activities of the United Front Work Department would be captured by Part 4 of this bill.
Thank you for the question, Chair, and I'll answer it this way. There are 3 triggers to require a registration obligation in the legislation. And so we have an arrangement, we have the 3 activities, whether they're communication with the public office holder, communication to the public, as well as disbursement of money to influence or in relation to a government or political process. Whether it's done by somebody that's operating under the United Front Work Department or some other organization, as long as those 3 elements are there, the registration obligation is triggered.
Mr. McGregor?
Just maybe to the officials, the part that we have here in this amendment where we're adding after line 20, where the governor and council may, so it's giving them the option, the cabinet the option, place the name of a foreign principal if there's a concern that that foreign principal is of particular concern. We certainly have seen, like, I believe there was a diplomat from the Chinese embassy who was named persona non grata. His name was shared all over the media. Are there any, I guess what could be some of the consequences of doing this if there is a principal who is of concern? Is there not some benefit to naming that person? That's, this person is a threat.
Thank you for that question, Chair. The commissioner will have discretion in applying the legislation and determining in any given situation if the person, an entity in Canada who's in an arrangement with a foreign body, if that person meets the definition of a foreign principal. And therefore the commissioner is well placed to make that, will be well placed to make that determination. And in addition to that, I would say that the commissioner will have at their disposal the ability to issue interpretations or bulletins and could communicate information via that way as well, and would completely retain the independence to do that in any given situation.
Any further discussion? Shall NDP 11 carry? No. So BQ 14 and BQ 15 can be moved because other things were not. That brings us to BQ 16. Monsieur Villemure, s'il vous plaît.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Just let me put my finger on the right page here. The purpose of this amendment has to do with the annual report, and that the Commissioner's annual report has to be submitted before the House of Commons and the Senate, rather than the Minister, to ensure greater transparency. It's one of the recommendations made by a number of witnesses, including Mr. Thomas Junot, who categorized the amendment as good practice. From a practical standpoint, on page 95 of Clause 103, well, rather, that in clause 113 be amended by replacing lines 22 to 28 on page 85 with the following quote: "To the end of the fiscal year, prepare an annual report on their activities during the year and submit it to the Speakers of the Senate and the House of Commons, who must each table it in the House over which they preside without delay after receiving it, or if the House is not sitting then, on any of the first 15 days on which the House is sitting after they receive it."
Merci, monsieur.
Thank you, sir.
Thank you, Chair. Two officials. The way the current legislation is written without this amendment, is the minister allowed to change or alter or request the commissioner to change that report?
Our understanding is the minister, when he says it must cause a report to be tabled, he receives the report from the commissioner and then turns around and tables it in the House of Commons without the ability to change it.
Okay, so they can't change, the minister couldn't change it, and the minister couldn't refuse to table, is your understanding as well, with the line of shall cause the
That's
report?
right. There's no discretion there.
Okay, so thank you. I think again, I understand the rationale behind this amendment, but I think with the report not being able to be changed and it must be tabled in the House, I don't see an issue with the legislation as is.
Thank you. Any further discussion? Seeing none, shall BQ 16 carry? Negative. Monsieur Villemure, BQ 17, s'il vous plaît.
Merci, Monsieur le Président.
Thank you, Mr. Chairperson. Just like BQ 16, this has to do with the special report rather than the annual report. We're moving in clause 113 be amended by replacing 29 to 36 on page 85. The Commissioner may at any time prepare a special report on any matter that is within the scope of their powers, duties and functions and submit to the Speakers of the Senate and the House of Commons, who must each table the report in the House over which they preside without delay after receiving it, etc., etc. Now, once again, there's a willingness that the Commissioner report to the Parliament rather than to the Minister directly, so that there can be a healthy distance between the Commissioner and the Minister. Arm's length, in other words.
O'Connell.
Chair, again, to officials, my concern with this, or perhaps you can outline some, if there is a concern, but my concern with this, if the report went directly to the House, there wouldn't be a review to ensure that anything that might be of national security, something that reaches national security level, that there would have to be some redactions or protections put in place in terms of that information being tabled publicly.
Thank you, Chair, for that question. In any report that's tabled in the House publicly, there are always concerns about classified information being shared in that manner, and when organizations, typically when they receive intelligence, there are caveats, there are limits of what can be done here, and so we would always be conscious that when the Commissioner tables the report, he would be or she would be able to do so in a way that protects the classified information.
And any of these reports could be reviewed by INSERA and SECU if there was to be something included that, let's say, needed to be redacted for the public version, there would be an opportunity to see the unredacted version in the right settings, because a minister can't alter the report.
And so the way I'll answer the question this way, Chair, INSERA and SICOP have an ability within the legislation to review the use of intelligence by the Commissioner. And so if they misuse the intelligence, I would assume that INSERA and SICOP would have the ability at least to look at that and make a determination. I'll admit I am not an expert in INSERA and SICOP reviews, but it is intended to include some level of accountability in the use of intelligence.
Okay, thank you.
Any further discussion? Seeing none, shall BQ 17 carry? Negative. Monsieur Villemure, BQ 18, s'il vous plaît.
BQ 18, thank you, Mr. Chair. Well, listen, we're talking about a review of the legislation here, and it was my concern during the hearings when we saw that the CSIS Act had not been reviewed. That was of concern to us, but when we drafted this amendment, it was upon the suggestion of a witness who indicated that a 5-year review were there to be an election next year and a minority government were to be elected that it collapsed, you could have 2 electoral cycles without any revision of the legislation. So what we're proposing is that in the first year after a general election, there be a review of the legislation mandatorily. So after each and every election, there would be a review to avoid an eventuality where there were more than one election over a 5-year period and there'd be no review of the Act.
Mr. Gahir.
Thank you, Mr. Chair. We support this amendment.
Great, thank you, Chair. So we know that this is going to increase the frequency of the reviews and the potential administrative burden as well. The question that I have for the officials is, we know that Canadian elections have been the target of foreign interference. Is a year post-election enough time to review the previous election to see if there was foreign interference and to take the proper recommendations?
Thank you, Chair, for the question. As we read the proposed amendment, it would require a comprehensive review of the Act and the operations of the Act, and so it would allow the Commissioner to review how the Act performed after the election, but not limited just to the election, but also just limited to what is in the purview of the FIDA.
Mr. Chong.
Yeah, to clarify something, we're on Block Amendment 18, are we not?
Yes.
Well, this is an amendment to require the House of Commons and the Senate to undertake a review of the Act. So it's a review by the House and the Senate, not of the Commissioner, if I'm correct.
I misspoke, your Chair, sorry.
Okay.
Okay, Mr. Gahir, are you done? Any further discussion? No? Shall BQ 18 carry? All right. On y va maintenant à BQ.
Let's proceed with BQ 19. Mr. Villeneuve, thank you, Mr. Chairperson. This has to do with the Minister's comments on a report within a 90-day period. Basically, we'd like the legislation to be more robust by requiring a response from the government. That seems to me to be desirable and logical.
Merci. Any discussion? Ms. O'Connell, please.
Thank you. I'm going to offer a sub-amendment. The first being that the minister must no later than, instead of 90 days, strike that out and replace it with 120 days after the day of which the report is referred to. And the second sub-amendment is to strike out 2.2.
It's been distributed? Everybody has it, okay.
I have extra copies if
Yeah, and you guys
you don't have it.
Okay. So discussion on the sub-amendment.
Thank you. In terms of the 90 to 120 days, that's just consistent with what the practice is for tabling reports and the timeline for a response. And the second striking out is just, I think it's important that the minister will determine the appropriate response of the report. So I don't think it's needed.
Merci. Monsieur Villemure.
Merci beaucoup, Monsieur le Président.
Thank you, Mr. Chairperson. I appreciate my colleagues' comments. I agree entirely with the 120 days. That's common practice. However, with regards to the striking clause 2, that's unacceptable to my mind. I'd like the minister to be obligated to respond and not leave it up to the minister's discretion to do so as he or she sees fit at any possible point in time.
See any further discussion? Seeing none, shall Ms. O'Connell's sub-amendment carry? I think that's a yes. Maybe we did a okay. On division? We're good? So we go back to the BQ 19 as amended. Any further discussion on BQ 19 as amended? Seeing none? Shall BQ 19 as amended carry? Yes. Okay. That brings us to G2. Ms. O'Connell or Mr. Gahir, or do you want to move G2?
G2, yeah. So this would amend the Foreign Influence Transparency and Accountability Act. It'll ensure that all pre-existing foreign influence arrangements are covered and that existing relationships won't be grandfathered in due to a lack of transitional provisions. It is quite lengthy, so I won't read it into the record, but it's been provided. Maybe we can get the official's word on this.
Thank you, Chair. This proposed amendment is because we noticed during the clause-by-clause preparation that existing agreements may not have been captured by the registration requirements of the Act, and the intent was to ensure that individuals who may have had an agreement on the day that the Act comes into force are required to register it within a 2-month period. That's consistent with what was done in the past, for example, in the Lobbying Act. It also avoids a situation where individuals may seek to register or enter into arrangements or conclude arrangements prior to the coming into force and therefore not be required to register their agreements.
Mr. McGregor.
Yeah, and I'm just assuming that because we did pass BQ 19, that these are just going to be renumbered as a consequence. Because we've added a new 32, so yeah.
Yes. Answer is yes. I like yes. Okay. Any further discussion on G2? Seeing none, shall G2 carry? Yes? Okay. So shall clause 113 carry as amended? Okay. There are no amendments submitted to clauses 114 to 117. Do we have unanimous consent to group them? Yes. Shall clauses 114 to 117 carry? Look at that. We've done all the amendments, and we're 5 minutes before we turn into pumpkins. Okay, so shall the short title carry? We still got 5 minutes to argue about it. So. Shall Schedule 1 carry? Shall Schedule 2 carry? Shall the title carry? Shall the bill, as amended, carry? Shall the chair report the bill, as amended, to the House? Shall the committee order a reprint of the bill, as amended, for the use of the House at report stage? Well, that brings us to a close. Thank you all for your rapt attention and your dedication and getting it done in a hurry. So,
Order, Mr. Chair. Thank you for your all your work over the last week and a half through,
actually to all
and the other members,
officials.
all the members of the committee and officials for all the work.
We've got this marvelous piece of software here that's going to keep track of our 5 minutes per party here too, but we won't get to use that this time. So it's an open question what we should be doing on Thursday at 8:15. Whether we have what action we should take. Whether we should sit. Whether we should meet on whatever. So I'll be looking for your input, the committee's input over the next tomorrow actually, and to see if there's any ideas of what we should carry on. Personally, after this long week, I'm okay with not sitting on Thursday, but. Anyway, please let me know, and we'll carry on. So with that, and with all thanks, go ahead.
I was going to move a motion here, Mr. Chair.
Mr. Caputo, to move the motion.
Yes, I hate to be a stick in the mud. Oh, I believe Ms. O'Connell's trying to get your attention, so I'll...
Okay, Mr. Caputo.
Okay. Given that, A, the Liberal Parliamentary Secretary said, boo-hoo, get over it, when committee was questioning the Minister of Public Safety, Democratic Institutions and Intergovernmental Affairs, the Honourable Dominic LeBlanc, about elected MPs that have knowingly helped hostile foreign countries and worked against Canada's interests. B, the committee call upon MP Jennifer O'Connell to apologize to all Canadians of diaspora communities who are the targets of foreign interference, to all Canadians concerned about the integrity of our institutions, and report this finding to the House. I don't mean to belabor this. I'll summarize my points in about 30 seconds. It's my position that as the Parliamentary Secretary, the member should be above reproach. This was a significant and is a significant issue, Mr. Chair, when it comes to the public safety mandate, and we had the minister there. It was reported by the media. I understand that sometimes heckling does happen, happens in the House of Commons. Most of us have done things that we've had to apologize for. I think this is similarly appropriate, given that it happened at the committee table when the minister was here. And with that, I'm done, Mr. Chair. Thank you.
Thank you. We have had appropriate notice. The motion is in order. I believe Ms. O'Connell wishes to speak.
Thank you, Chair.
Followed by Mr. Gayer.
Thank you, Chair. Appreciate the opportunity to speak on this motion. I find it quite disappointing after a meeting where we dealt with very serious legislation. Mr. Caputo seemed to be silent on that as well, which is interesting, and instead decides when it comes to foreign interference, would instead prefer to focus on political antics. Mr. Chair, it's very clear, and although the blues have not been released for that meeting, it was very clear, because there's video, that the Conservatives are misleading, frankly, this committee with this motion and the language around it, because the intervention with Mr. Jennis was very clear only about heckling. Mr. Caputo, Mr. Jennis was upset that I had heckled Mr. Caputo, and in fact interrupted Mr. Gahir's line of questioning. There was no mention of the NSECOP report. There was no mention in this interaction of the findings and the report, and it was simply about the fact that Mr. Caputo was upset I heckled him. An ironic point, given the fact that in that very same meeting, Mr. Cooper was admonished by the chair for berating a witness. So while I would acknowledge and say heckling is certainly not ideal, it does happen all the time, and I would for sure apologize for heckling during Mr. Caputo's intervention. However, what happened and what took place subsequent of that meeting was the fact that the Conservatives have now spun the interaction away from the actual issue, which was a debate over heckling, and spun it into something it's not. And now including the point about apologizing to diaspora communities and making the issue about the NSECOP report, which, again, anyone can watch the interaction and see the Conservatives did not raise diaspora communities, did not raise foreign interference, they did not raise the NSECOP report. All they talked about was being upset that Mr. Caputo was interrupted by myself. And it's this hypocrisy that I find so egregious, given the lack of respect that is provided to all members, in particular by some of the Conservatives, in fact, the mover of this motion, who has heckled and interrupted not only Liberal members, Bloc and DP at different times. We can have a debate about decorum, but what I won't accept is this mischaracterization of the events when it's very clear on the record that the Conservatives never even mentioned foreign interference in that intervention. To now purport it to be something that it's not, I find egregious. And so I had to wonder, why would the Conservatives try to spin something that is very clearly provable through Hansard and through video, frankly, because all of our meetings are recorded. And then I realized it's because the Conservatives would rather speak about me and make this a political
Chair, point
exchange.
of order. Point of order. Sorry, Mr. Collins. Point of order.
Mr. Shipley on a point of order.
Sorry to interrupt you. This has been a long week and a half, and staff and the witnesses have worked very hard. I was just wondering if we could have UC to let the witnesses go.
Absolutely. We have unanimous consent to release the witnesses? Yes. Thank you all for your interventions. Thank you for your patience. And I'm sure we'll see you all again one day. All right. And do we have unanimous consent to let our legislative clerks? Please, thank you. Next time dessert. Okay, and we're in for the long. Okay. All right. Okay, so carrying on with Ms. O'Connell. I believe Mr. Gahir is next, but go on.
Thank you, Chair. So, Chair, so it made me wonder why the Conservatives would, after the fact, because also remember being in that meeting, no one questioned the interaction as being about the real threats and real issues of that diaspora communities are facing around foreign interference. That was not part of the interaction. It was only after, when Conservatives took to Twitter to spin and mislead, that accusation was made. So it made me think, why are the Conservatives, after the fact, trying to distract from what really took place in that meeting? So I started to do a little bit of a look at why the Conservatives would rather focus on me and an interaction about heckling as they heckle me. The irony is not lost on me. Why they'd rather focus on me and not the very real issues of foreign interference. Well, so let's go about some of the things they don't want me to talk about. Some of those things include the fact that in 2010, it was Prime Minister Harper, National Security Advisor, who we had a witness on foreign interference, who actually advised and warned about the very real threats of foreign interference. Nothing was done. It was under Mr. Harper's government that Canada was urged to join other Five Eyes countries to create a parliamentary committee for national security oversight. Again, that advice was ignored, and it was actually that was the crux of my intervention with Mr. Caputo, was the fact that he spoke about NSECOP as the only reason we know about these allegations, and my interaction was, because I could not understand the irony that they were unaware of, was the fact that it was the Conservative government that actually refused to create NSECOP, and then actually at one point in the last number of years got upset, removed members, put members back. So to now be using NSECOP when it suits them after they refuse to establish it, I couldn't contain the irony in that interaction. And then when it was asked to their current leader, when he was, why he did nothing to deal with foreign interference while he was the Democratic Institutions Minister, he essentially said that, well, it wasn't politically in their interest to do so at the time. When we created the motion to establish NSECOP, Conservatives voted against it. We established the Site Election Committee, which is a nonpartisan oversight committee establishing a mechanism to alert the public and to Canadians for foreign attempts to interfere in our elections. So, Mr. Chair, our government has continuously implemented legislation to deal with foreign interference. We've taken it seriously since we formed office in 2015. I've continually highlighted the hypocrisy that Conservatives have made on this issue, and I find it deeply offensive to mislead and misconstrue what actually took place at this committee and the interactions in a way to kind of bury and distract from the fact that the Conservatives' record on foreign interference is pretty abysmal. I find it deeply offensive to suggest that diaspora communities who are have very real implications of foreign interference, that they would be treated in a manner to mislead them of what that actual interaction was. I find deeply concerning, and frankly, I have faith in Canadians to see through the partisan games that are happening here today. So I'll leave it at that, Chair. I find it incredibly disappointing that we even have to engage in this sort of partisan behavior on an issue that is so important. But I will not stand here and allow the mischaracterization of what actually took place to go unchecked. And luckily, we have video and Hansard to clarify the record, and I'll ask for a recorded vote.
Thank you. We go now to Mr. Gahir.
Great. Thank you, Chair. This motion calls on Ms. O'Connell to apologize to Canadians of diaspora communities that are the targets of foreign interference. I just find that very rich because when we were in that committee and asking questions, I am the member of a diaspora community that is a target of foreign interference of the highest degree. And I was interrupted by Mr. Genuis and his point of order, and that's when this exchange happened. And I do agree that Ms. O'Connell's words are being mischaracterized, and we really do invite all Canadians to watch the testimony and read Hansard. And I don't know if it actually even captures all the crosstalk that happens within committee. So I'll leave it there.
We go to Mr. Lloyd.
Thank you, Mr. Chair. And I have to say, I wasn't there for the meeting in question, but I find it very hypocritical that members of this Liberal Party are citing the testimony of former CSIS Director Richard Fadden at our committee last week, when it was members of this Liberal Party, including the current Minister of Health, Mark Holland, who issued a report calling for the resignation of Director Fadden because of his comments that he has now been vindicated for. Comments where he spoke about the threat of foreign interference in Canada, threat to members of our political class, and even saying that members of our political class had been subverted by foreign powers. He was saying this back in 2010. I want to just list off some of the recommendations that the Liberal Party made in their report. Recommendation 1, that the Minister of Public Safety and the Prime Minister be held responsible for Director of CSIS's unacceptable statements during the interview. That the Government of Canada renounce categorically Mr. Fadden's statements and apologize to the Chinese Canadian community and other cultural communities implicated and offended by Mr. Fadden's allegations concerning growing foreign interference in domestic politics. Recommendation 3, that the Minister of Public Safety require Richard Fadden to resign for his statement. And recommendation 4, that the Parliament censure the Minister of Public Safety and the Prime Minister for allowing the Director of CSIS to exceed his statutory mandate by making dramatic and irresponsible statements to the media, sowing doubt in many members of the public regarding the probity and loyalty of municipally elected officials and provincial ministers. Those are just some of the things that the Liberal Party of Canada was calling for in 2010 when they were attacking the Director of CSIS, who was warning us, and now they have the gall to stand in this committee today and lecture Conservatives about the remarks of Richard Fadden, who has courageously for 14 years, despite the vilification that these Liberals put on him back in 2010, stood up for our country and defended our country from the threat of foreign interference. And I'm glad to see that he's been vilified today. Thank you, Mr. Chair.
Vindicated? Okay. There being no more speakers, Mr. Caputo.
Yes, I agree. This was all caught on camera, and Canadians can decide for themselves. I know that it was actually the media who were in the back of the room who broke the story in almost identical language to that which was put out by the Conservative Party. I think it was Mercedes Stevenson who actually reported it first, and then was corroborated by another reporter who was in the room. So, indeed, Canadians will judge for themselves.
Any further interventions? Recorded vote, please.
Mr. Biddle?
No.
Mr. Gahir,
No.
Mr. MacDonald, Ms. O'Connell, Ms. Zaid,
Nay.
Mr. Caputo,
Yes.
Mr. Lloyd,
Yes.
Mr. Motts,
Yes.
Mr. Shipley,
Yes.
Monsieur Villemur,
No.
Mr. McGregor,
I abstain.
Five nays, 4 yeas.
The motion is defeated.
Yeah.
On consent, no, point of order. I think there's, if you seek it, I think you'll find agreement that we not meet on Thursday.
Is that
Unanimous
agreed?
consent.
Done. Thank you. Thanks, everybody. This meeting is adjourned.